For quite a while now, we've been talking about artificial intelligence and the way that it is already changing our lives, the ways that it could change our lives, and the ways that it's being applied. Well, AI is one of those things that, people have been using in a variety of different ways, including to come up with new products, new ways to do things, besides just, writing letters for you. And now the U.S. Patent and Trademark Office has said that to obtain a patent, it can't be AI made. What they claim is that a real person must have made a significant contribution to the invention, and that only a human being can be named as an inventor on a patent. To talk about it this morning, he is the patent professor, attorney John Rizvi, joining us on the wake-up call this morning, and you guessed it, his specialty is patents. Hey, how you doing, Prof?
Yeah, terrific. It's always a pleasure to be here.
It's always a pleasure to have you on. So what exactly constitutes a significant contribution when we're talking about the decision that was made by the U.S. Patent Office? And how do they go about even determining that it was the person that made the significant contribution and not the AI?
Yeah, so these are terrific questions, and I want to take a step back as to what prompted them. I mean, it's not like the Patent Office voluntarily came forward and tried to clarify this. They were under an executive order from President Biden on October 30th because of all the confusion on who can be an inventor with regard to inventions created using AI. He gave them a deadline of the end of February to provide some clarity. And unfortunately, with most legal matters, right, like this is the clarity we have, is a significant contribution. And what is a significant contribution? So to really understand that, you have to look at the laws have been struggling with who owns an idea or an authorship way back from the constitutional basis for intellectual property. And it's the Article 1, Section 8, Clause 8 gives Congress the power to provide limited monopolies to authors and inventors. And that has been determined to be that it has to be a human. So the ultimate author or inventor has to be a human. Now, the question comes in is, when is AI a tool, and when is it actually doing all of the significant contribution? So those proponents that say, hey, AI invention should be protectable, no different than an inventor using any other tool or an author using any other tool, have kind of said AI is similar to a painter's paintbrush or a sculptor's chisel, is that they are using it as a tool, but the ultimate creativity, the ultimate control is by the human. The problem is, as AI gets more and more sophisticated, the level of creativity in the prompt that you're putting in is not commensurate with what you get back. And that's, a painter can't just, every brush stroke is done with his hand. Same thing with a sculptor. So this is, yes, AI is a tool, but it's so much more powerful than any tool authors or inventors have ever had in history that the courts are grappling with. Well, when is the human being the author versus the machine? And the Patent Office has made it clear in a case, the federal district court in the case of Stephen Thaler as an inventor that listed AI as the inventor, a non-human inventor, and that was shot down. You cannot have a non-human inventor. So the question is, if it's a human inventor, when is the contribution significant? And my prediction is what the courts and the Patent Office is going to do is look at case law on when somebody is a joint inventor or a co-inventor. So sometimes when you have two inventors and one person does 95% of the idea, the other person does a smaller percentage, this is not a new determination. We've always had to figure out, okay, when do you count as a co-inventor, or a joint inventor? And I think that's what ultimately it's going to come down to is, was your contribution sufficient in AI? And a big factor, I think, is going to be how much control you have on the output and how much editing you're permitted to do with the final product. So that's going to play a role as well.
All right. We're going to start parsing this. The first question is, okay, so this guy files for this patent, and he said it was invented by AI, and they said, well, you can't patent it. So what does that mean, that whatever it was that he invented goes automatically into the public domain?
Yeah, exactly. If he cannot get exclusive rights to it, then it's not the ownership is not with him.
So is the ownership with the person that created the AI software? So,
again, the software would be just the tool. So, This is one of these odd. There's a gap, of course, right? Because robots cannot own things. So, conceivably, the AI would have title to it, but that doesn't make any sense. Mm-hmm. The owner of the AI doesn't have any more rights to it than the person that sells somebody a paintbrush has rights to the final painting that's done.
Okay.
There's no ownership in a case like that.
Okay.
The right way to file would be to list himself as the inventor, and that way the patent office is going to have to determine whether your contribution is significant, and it really depends. It's going to come down to a factual analysis of how, what prompted you enter, how much creativity, how whether it goes beyond a common prompt that doesn't take any unusual talent or skill or creativity.
Okay, got it. By the way, the patent professor, Dr. John Rizvi, joining us on the Wake Up Call. All right, then I have to ask this. If I had, and I haven't, but if I had used AI to create some brand new widget, I don't know, nuclear fusion, and I go to patent it, but I don't say, oh, yeah, I also incorporated AI into this, how would they know?
No, brilliant question. There's, they really wouldn't. And there's no requirement that you disclose that AI was used in the creation of an invention. There's absolutely no requirement for that. So that's something that is not, they're not testing for that. That's not one of the basis for the criteria for inventorship, is that AI was not used. So you're right. I mean, in this case, the inventor not only disclosed that he used AI, he listed AI as the inventor. And you bring up a good point. Well, gosh, he almost shot himself in the foot. Why did he do that instead of just not disclosing that AI was used? The patent office does have. There is precedent for invalidating a patent where it's obtained through fraud, and it's going to remain to be seen whether that is actually done in cases where it's found out later on that the actual that AI was used and that the contribution from the inventor was not significant, and that actually the AI, the machine, is what made the significant contribution. Unfortunately, this is what happens when technology is moving faster than the pace of the law. The law is always struggling to catch up, and this isn't new. I mean, the Supreme Court actually dealt with this way back in 1884 when a photographer tried to get a copyright on a photograph, and the question then was, hey, the camera is doing the it should be the author, and we can't give authorship to a camera. And the Supreme Court held, well, yes, the camera is taking the picture, but the photographer is choosing the angle, the lighting, and there's a lot of choice made by the human being. And they said, a photograph can be copyrighted because it's a tool, and the ultimate author is the inventor, is the photographer. So that may be, they're drawing similarities to that with using AI. The difference, and you can see it even in photography, cameras have gotten so much more sophisticated, but a photographer is still the author, and the photographer still has the copyright because he's carrying the camera, pointing it, shooting it. There is a lot of significant contribution, if you would call it that. But these robots and machines get more and more sophisticated and carry more of the burden, at some point it's going to be that, hey, the human really didn't contribute much at all, maybe pressed a button, and the machine did everything else.
All right. Unfortunately, we're out of time. Dr. Rizvi, we appreciate you joining us on the Wake Up Call this morning.
Thank you.